Check to see if you're eligible for a plan with extra benefits. Call 800-693-5145. 800-693-5145. Welcome back to Court TV Live. Let's get you back into the courtroom. The judge has begun instructing the jury. These are preliminary instructions before the opening statements. Let's dip in.
The attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Testimony by witnesses is evidence. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law applicable to the case. After the final instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the argument of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case amongst yourselves. Your verdict must be solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, please notify court personnel immediately. During the course of the trial, the court will take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence.
All right, as the judge continues to instruct, let's talk about what we're going to be watching in just a minute. Joining us, former Assistant State Attorney and Civil Rights Attorney Sue Ann Robinson is in Fort Lauderdale, Florida, and Andrew Mishlev is a criminal defense attorney in Milwaukee. Good morning to both of you. Here we are, opening statements 8 years after the fact of this battle. Sue Ann, what are you going to be listening for from the state of Florida here?
I'm going to be listening for how the state is going to give the jury the context, set the picture, set the mood for what happened on that day. There's been a lot of arguing from the defense about what the state should be able to say in terms of provocation, what led to the argument. The defense is doing a good job in their arguments of trying to make the entire context of the confrontation be just the actual shooting and the popcorn throwing, and to try to limit everything else, saying that it's not relevant. But in this case, the judge has already thrown out the stand your ground. She denied the stand your ground motion. So they're traveling under a traditional self-defense. And I think for something like that, they do have to have a context. The jury does deserve a context to understand that this is an empty movie theater. There isn't anybody else there. Yes, it's popcorn that's being thrown, and that Mr. Reeves was the initial aggressor in terms of he initially made contact with who he would eventually, with the decedent. So the defense is doing their job. The defense is going to defend, and they're trying to limit that information. And the state needs to get out as much context as they can so that they can show that this was just a normal day. We're all watching a movie. We're in the previews. There's nothing, creating an emergent scenario that should have led to a shooting death.
Andrew, how do you tee up, if you're the defense, the notion of self-defense in this case?
Well, self-defense requires that Reeves not only believe that he was threatened with great bodily harm or death, but that belief was reasonable. And of course, the prosecution theory is it's not reasonable if somebody comes after you with popcorn to feel that you're being that threatened. So what I'm going to be listening for is, what is it that made Curtis Reeves feel like this was such a threatening attack on him. And the devil will be in the details. Was the popcorn thrown in his eyes? Did he know it was popcorn? And there's some testimony or some evidence that Olson's wife was holding him back. Did he feel that he was really under threat? Or, as the prosecution would like to put it, is this just a man who was angry and lost control of his temper? And there's some press reports that he made a statement to the effect of, "I'll show you to throw popcorn on me." If that statement is true, I don't know whether it was actually said or not, or who might have heard it, but if something like that comes out, that could be very damaging to Mr. Reeves. So I'm going to be listening in the opening statements for these details about the context of, at that moment, did he have a reason to feel threatened? Not just did he feel threatened, but was it a reasonable feeling?
And what exactly was that reason? We'll also look for a clue of whether or not the defendant is going to take the stand. Sometimes it's promised right here in the openings. Let's go back and listen to the tail end of the judge's instructions for this jury.
Including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against him or her, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions, such as serving time in jail, paying a fine, or both. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of the case. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You have been provided with a notepad and a pen for use if you wish to take notes. That's in your envelope there. Any notes that you take will be for your personal use. You will be able to share your notes with your fellow jurors during your deliberations. Not any time other than that, of course, because you're not going to discuss anything amongst yourselves prior to your deliberations. However, you should not take them with you from the courtroom. During recesses, just leave them on your chair and the bailiff will watch over them. After you have completed your deliberations, the bailiff will deliver your notes to me and they will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. At this time, the attorneys will have an opportunity to make opening statements in which they may explain to you the issues in the case and summarize the facts that they expect the evidence to show. After all the evidence has been received, the attorneys will again have the opportunity to address you and make their final arguments. The statements that the attorneys now make and the arguments that they may later make are not to be considered by you either as evidence in the case or as your instruction on the law. Nevertheless, these statements and arguments are intended to help you properly understand the issues, the evidence, and the applicable law. So please give them your close attention. State, Mr. Rosenwasser.
Members of the jury, what you're going to learn during the course of this trial is that back on January 13th of 2014, Chad and Nicole Olson decided to spend the day together. It was a Monday. They had not been spending that much time together based on their work schedules. They were also raising their daughter, Lexi, who at the time was just under 2 years old. So they decided on that day that they were going to put Lexi in daycare and go out for breakfast, possibly shopping, maybe over to Wiregrass. And eventually, at some point on January 13th, they decided to go to the Cobb Grove Theater. They were going to see the movie Lone Survivor. That was going to start about 1:20 in the afternoon. Now, that's located at 6333 Wesley Grove Boulevard in Wesley Chapel here in Pasco County. So what you're going to learn is that they go to the theater. When they get there, they purchase their tickets. They then go inside to the concession stand and they buy some snacks. After that, they decide to go into the theater. Now, this theater is theater number 10. And what you're going to learn is that theater number 10 is a Cinebistro. It's a general theater and a Cinebistro. And you may know what a Cinebistro is, but basically it's an area of the theater where you can order food kind of like in a restaurant setting. You don't have to go to the concession stand. And this particular part of theater number 10 is separated from the general theater by a wall. In fact, there's a separate entrance. Now, what you're going to learn is that when Chad and Nicole Olson decided to go into theater number 10, they were looking for some seats that were towards the back of the theater. That's where they like to sit. So they chose the row that was to the second to back last row. And they went over towards the middle. Nicole Olson sat down, and on her right was Chad Olson. Now, at this point in time, there wasn't that many people in the theater. People were still coming in. They had their snacks. They were talking. And at some point in time, one of them, doesn't matter who, one of them wanted some more snacks of some type of candy. Chad Olson gets up, leaves the theater, goes back to the concession area, and of course, more and more people are coming into theater number 10 to see the movie. When Chad Olson comes back, he sits down. Again, he's still on Nicole Olson's right. And at some point in time during this, the defendant and his wife, whose name is Vivian Reeves, comes into the theater. Now, when they come into the theater, they decide to sit in the very back row. Now, there's a wall behind them because behind that wall is where the Cinebistro area is. They go to the very back row, walk all the way across to the middle, and they sit down. Now, to kind of paint a picture for you as to where everybody's seated, and you're going to see this in video, and people are going to tell you where they were sitting. Picture this. So, in the very back row, you're going to have the defendant. He's sitting in the middle. Directly in front of him is Nicole Olson. To Nicole Olson's right is going to be Chad Olson. Behind Chad Olson is the defendant's wife, Vivian Reeves. So stated another way, to picture it a different way, you have the defendant in the very back row, basically in the middle. An entire row in front of him and an entire seat over to the right is where Chad Olson is sitting. That's the layout of the theater on this particular day when this shooting occurs. Now, what you're going to learn is that there were many people that came into the theater. In fact, at the beginning of jury selection, a long, fairly long witness list was read to you. And you heard from the court and you heard from us that you're not going to hear every single witness that's on that witness list, because there was a fairly large law enforcement response, and not everyone in the theater has relevant information. Some people became aware of the shooting afterwards. Some people didn't see anything. Some people didn't hear anything. And some of the law enforcement officers were there for basically security. So you're not going to hear from every single person. The people that you are going to hear from, they have different parts of the whole picture, meaning this. Some of the witnesses that you're going to hear from heard the beginning of what happened. Some heard the middle, some heard the end. Some saw the beginning. Some saw the middle, some saw the end. Some heard and saw basically everything. Now, you are going to learn that there is a video. And by video, I mean just that. There is a video and not an audio. The video comes from the Cinebistro area. There are 2 cameras inside of theater number 10 on opposite sides of the theater. Now, they were designed, as I mentioned, to capture the Cinebistro area, but they did capture some of the general part of the theater and did capture this shooting. Did capture people coming in the theater, did capture people leaving the theater, the defendant leaning in and talking to Chad Olson, things of that nature. The video did capture that. Again, there's no audio. The audio is going to come from witnesses. Now, what are you going to learn? Well, people are going to tell you what the lighting environment was. So people in the theater are going to tell you the following. Now, don't pay particular attention to any single one-word description, because you can't adequately describe something in one word. In other words, to be pigeonholed to one word. For example, in everyday life, if someone were to tell you that someone was of a medium build, well, one person might think of that as a thin person, and another person might think of that person as a heavier person. But the description, when people elaborate, that's how you're going to be able to determine exactly what happened. So in this case, what are you going to hear from people that were in the movie theater? You're going to hear that at the time of the previews, now, this shooting occurred during the time of the previews. So when I talk about the lighting conditions, it's the same during the time of the shooting. So what witnesses are going to tell you is that it was light enough for them to see in the movie theater. The lights weren't full, they weren't full house lights. It had been dimmed. So if you hear the words dim, dimmer, pretty dark, darker, that sounds like it's painting a different picture, but I submit the evidence is going to show you that when everyone came into the theater, their overall description, forget the one word, was that they could see. They could see aisles, they could see rows, they could see seats, they could see people in those seats, even at a distance. They didn't have any concern during these previews. Again, this was the time of the shooting, that they needed a flashlight or their phone to offer some light for them to navigate in the theater. It wasn't dark like when the movie starts. That's the lighting conditions at the time this shooting takes place. And that's the lighting conditions you'll learn about when Chad Olson is on his phone. Now, what happens? The previews start. People are seated inside the theater. Again, you have the defendant in the very back row in the middle. In front of him is Nicole Olson. Over to her right is Chad Olson. Behind Chad Olson is Vivian Reeves. The previews start, and there is a message that you should turn your cell phones off, basically. Now, here's what you're going to learn. Chad Olson had his cell phone on. Now, by on, this is what I mean. Chad Olson, the evidence will show you, he's not talking on his phone. He's not conducting a business transaction. He's not talking to a friend, a family member, not having a loud conversation. By on, literally the phone is on. That's it. The evidence will show you that there was a white light coming from the phone. That's how the phone was on. You're going to learn that almost immediately or very close after the time of that message, please be responsible, turn your cell phone off, whatever the message is. Very close in time to that, without really waiting, the defendant over here leans in to Chad Olson and Nicole Olson, because the evidence will show you the cell phone had a light on it. Now, what you're going to learn is that this defendant leans all the way in, and it's going to sound silly when I say this, to Chad Olson's personal space. And you're going to see this on video because it's captured. Not only is a witness going to talk to you about it, but it was captured on video. The defendant leans all the way in from his seat and basically gets back to the left ear of Chad Olson. So the defendant's head is basically in their space. You're going to learn from a witness that the defendant's tone was kind of demanding. Turn your cell phone off. Now, at that point, the evidence will show you they're kind of taken aback by this. Now, Chad Olson did not turn his phone off. Now, here's what you're going to learn what was going on that phone. He was looking at Facebook. social media. There was a website that he was looking at through Facebook, and they had been looking at it. The evidence will show you, of course, that's no reason to shoot another man. But here's what you're going to learn. That the defendant leans all the way forward, tells Chad Olson to turn his phone off. Chad Olson doesn't turn his phone off right away. Now, in a perfect world, should Chad Olson have turned his phone off? Yes, but the evidence will show you that you can't kill someone for that. Now, the evidence will also show you this, that the defendant waited a little bit, asked him again to turn his phone off, then got up to leave the theater. Now, the way he left the theater is going to be important for you to consider during the course of this trial. The overall attitude and demeanor of the defendant that's going to be described to you during the course of this trial is very important. Because one of the charges the defendant's been charged with is a crime called murder in the second degree. And all of these laws are going to be explained to you at the conclusion of the case when the judge gives you all of the instructions. But a part of murder in the second degree is that we have to prove that the defendant acted with ill will, hatred, spite, or evil intent. Ill will, animosity, bitterness, spite, annoyance. So the defendant's demeanor and his actions will play into whether or not there was ill will, hatred, spite, or evil intent. So here's what's important about when the defendant gets up to go tell the manager that this white light is bothering him during the movie previews. The defendant gets up, and as he goes out the aisle, he's mumbling to himself. Now, you're going to hear from a witness who's going to tell you that based on her life experiences, he appeared to be agitated and angry. The evidence is going to show you that he was. He was annoyed that Chad Olson still had that phone light on. And he walks out, he's mumbling to himself. Now, as he's walking out fine, meaning this. Whenever anyone navigates through an aisle or a row in a movie theater, you necessarily have to move around people and it's kind of awkward. But he was able to do that. There's a video that you're going to see that shows him getting up and walking out of the theater. People watch him leave the theater. Memories in the back row. Goes all the way down the steps. There might be 13 rows. You're going to see pictures. You can count for yourself. Walks all the way down the ramp, all the way to the manager's desk. Now, when he's at the manager's desk, what happens? Well, when he's there, and again, there's no audio. There's going to be just a video. Watch his demeanor. Now, I don't mean to present to you, and I'm not painting the picture to you that when he's at the manager's desk, he's banging on the desk and screaming and demanding action, because he's not. But when we're talking about the demeanor of the defendant, the evidence will show you this ill will or spite. Watch his arms, watch his hands, watch his fingers, watch his facial expression. He's there for about 3 minutes. Walks back into the theater, all the way up the ramp, around the corner, all the way back up to the back row, all the way across again into the middle. Now, the witnesses you're going to hear from are going to tell you this. They're going to tell you that the defendant did not appear to have any disability. He didn't have a cane, didn't have a walker, didn't have a wheelchair. The evidence will show you, and it sounds like a silly thing to measure, the defendant parked 133 yards away from the theater. Now, it sounds silly again. It's a football field and a third, but there's no handicap placards. The defendant's not handicapped. Wife didn't have a handicap placard. You're going to see video of the defendant as he purchases tickets. He's in the lobby area, in the concession area, walking to and from the theater. Now, why is that being brought up? Well, the evidence is going to show you this, and we're going to talk more about it in just a little bit. But the defendant gives a taped statement to law enforcement. Freely and voluntarily waives his rights. And there's going to be a picture painted during this taped statement. And one of the things you're going to learn in this taped statement is the defendant states he's got arthritis in his back and his knees. Well, the evidence will show you that, let's say that's all true, it's very, very bad. The evidence will show you that's no reason to shoot and kill another person. However, when you see the actual pictures, meaning the video, and you listen to the witnesses, you're going to see he was completely fine. Now, what happens? When he walks back into the theater after speaking to the manager, coming back across the row. Now, it doesn't matter exactly when this happens. It's either as the defendant comes back into the theater, as he's sitting back down, or even some seconds after he's fully seated in his seat. Doesn't matter. But the defendant in this taped statement indicates that he reinitiates contact with Chad Olson. Now, what's the evidence going to show you in this case? Chad Olson was talking to someone earlier, and it was the person in the row in front. At no time will the evidence show you that Chad Olson is volunteering to talk to the defendant. The defendant's always the one initiating the conversation. And as the defendant comes back, based on his own statement, he indicates that he reinitiates contact with Chad Olson and tells him this. And here's something that's important you're going to learn during the trial. Chad Olson did, in fact, turn off his cell phone. The phone was off when the defendant came back into the theater. The evidence will show you that the defendant could have just sat back down in his seat and everyone could have watched the movie and everything would have been fine. The phone was off, no problems. The evidence will show you that after there's a conversation, Chad Olson is in his seat. Now, what the defendant states to Chad Olson is, I see you put your phone away. I told the manager for no reason. Now, I submit the evidence will show you that there was no reason for that. Regardless, the statement was made. Based on the defendant's own statement, Chad Olson turns around in his seat. Now, when you listen to the defendant's taped statement, pay very close attention to the words he chooses to use and the order in which he uses these words. The defendant states Chad Olson turns around in his seat, and now Chad Olson says some words to him. Now, in a perfect world, should that have happened? No. The evidence will show you can't shoot someone for that. Chad Olson does turn around and starts to have some words with the defendant. Mind fairly quickly. It's fluid. Chad Olson stands up and continues, and he looks at the defendant. Chad Olson's in his row. Remember, he's an entire seat in front of the defendant. An entire row in front of the defendant, and an entire seat over. And during this conversation, while he's standing up, he says, if it's any of your business, and they're Zillow, buying a car, buying a house, checking the stock market, Facebook, texting, you can't shoot and kill somebody. It's irrelevant. I submit the evidence will show you he was just trying to get the defendant to leave him alone, and that's what he chose to say. Really doesn't matter. So the evidence will show you this. Chad Olson is standing up. And as he's standing up facing the defendant, and you will see this on video, Chad Olson reaches over with his right hand. And he reaches over into the defendant's lap and he grabs something. Now, this might sound silly. What does he grab? Does he grab a deadly weapon out of the defendant's lap? The evidence will show you absolutely not. Does he even grab a big tub of heavy popcorn? No. Here's what you're going to learn during this trial. Chad Olson reached over with his right hand into the lap area of the defendant and grabbed a bag of popcorn. And he grabbed that bag of popcorn and he brought it back and he flicked it at the defendant. Now, the evidence will show you, of course, in a perfect world, should Chad Olson have grabbed a bag of popcorn and tossed it on the defendant? Well, of course not. The evidence will show you can't shoot and kill another person over that. So the evidence will show you this, because there's a couple of things happening simultaneously at this point. So I want to break it down just a little bit. Chad Olson stands up. He's facing the defendant, says something about texting his daughter. He reaches over, grabs the bag of popcorn, and flicks it. Doesn't pull it back, isn't using it like a bat, just flicks the popcorn on him. His hand is now coming back. At about that very same time, Nicole Olson, remember, she's sitting in front of the defendant. She's starting to reach over with her left hand while this is happening. And in the process of getting up to say, honey, it's just sit down. So her hand's up. When her hand is up, and while Chad Olson's hand's coming back from that popcorn toss, this defendant shoots. So taking a step back to kind of go over what happened, the evidence will show you Chad Olson is sitting in his seat, turns around, says a few words to the defendant. Stands up, says a few words to the defendant, reaches in, grabs the popcorn, flicks it. Now, this is important to watch on the video because it goes back to arthritis, my back, my knees. What you're going to see on the video is the defendant, in an incredibly quick and swift maneuver, reaches his right leg out as he's leaning back, goes into his pocket to get his firearm that he's brought into the theater, pulls it out, and lunges forward to shoot Chad Olson. The evidence will show you he's not back cowering in fear, but watch the manner in which he grabs this firearm, how quickly he is able to do it, how fluid he's able to do it, and how he lunges forward as he shoots. And why is that important? Well, to go back to the instruction of ill will, hatred, spite, or evil intent. The evidence will show you he was mad. Chad didn't listen to him, and Chad threw popcorn on him. So what happens next? After that, Chad stumbles. He begins to turn to go towards the aisle. He goes down a couple of seats. He's shot in the chest. He can't make it to the aisle even. He falls down on other people in the theater. Nicole Olson's finger is almost shot off. It's almost severed from the bullet going through. She's screaming. Chad falls on the ground. There happen to be nurses and other people there that try to help Chad Olson as he's laying on the ground with that bullet in his chest. Now, ultimately, of course, Chad Olson dies. He's basically dead in the movie theater. There happened to be an off-duty deputy, not from the Pasco Sheriff's Office, but from another county in the theater. He gets up, you're going to see this on video, and he walks over to the defendant. The defendant has his gun on his lap. It's taken from him. The gun eventually is given to a sergeant at the Pasco Sheriff's Office. That gun is eventually sent to a place called the Florida Department of Law Enforcement. Now, during this trial, there's going to be some stipulations. Stipulations are agreed upon facts, so to speak. You get these, there's not going to be any other testimony on the matter. They're basically just accepted to. Now, one of the stipulations you're going to learn is that this firearm, the one the defendant used, it's a .380, was sent to the Florida Department of Law Enforcement. There's a shell casing there. Shell casing came back to that gun. Now, that's not an issue in this case because this is not a whodunit case. The important part of that stipulation is that this firearm, the one the defendant brought into the theater, was working properly. Didn't malfunction, wasn't an accidental shooting. This was an intentional and purposeful shooting. The gun was working fine. Now, people are working on Chad Olson. This other deputy is with the defendant. People called 911. Now, you can imagine when there's a 911 call about a shooting in a movie theater, there's a fairly large law enforcement response, and there was. And this is when the investigation begins. Now, people that were in the theater, they go to different parts of the theater. Some are in front of the screen, some are in the concession area, the lobby. Now, fire rescue was called. They had to what's called stage, meaning they had to wait for the movie theater to be secured before they could go in to try to help Chad Olson. When the deputies came in, they made sure the scene was secure. They were trying to help Chad, dealt with the defendant. Fire rescue comes in, everyone goes to the hospital. Chad's life can't be saved. Eventually, Nicole has work done on her finger. Now, while deputies are there and people are in different parts of the theater, they hand out these blank forms. And sometimes they're called written statements. And people are not given any instructions on how to fill these out. They're just told to write down what you know. Now, of course, these are people in a theater who aren't law enforcement officers or lawyers, and they don't know how much to write or how little to write. Some people write one sentence, some write 10 sentences. It's basically just what they saw. Some people are going to tell you they're really upset by what they saw. And law enforcement used this as a first step in their investigation. Read those written statements, tried to figure out who they needed to talk to in some type of order. Who they were going to talk to that day, who they were going to follow up with later on. That's what happened with the written statements.
Scott Rosenhauser delivering the opening statement for the state of Florida. We need to slip in a break. Back after this, you won't miss a thing. We'll pick it up right where we left off.
Up until the
Derek Chauvin, convicted for the murder of George Floyd. Now, the other 3 officers face charges in federal court.
And Court TV teams are live with every update.
Live updates today on Court TV.
We, the jury, find the defendant guilty.
Kim Potter waits for sentencing in the fatal shooting of Dante Wright.
The mistaken taser sentencing. Live coverage Friday, 10/9 Central on Court TV.
Did you know that you don't have to be 65 years old to qualify for
written statements. Some people were near them, but no one was telling other people what to write or what to say. The witnesses that come into court are going to tell you what they personally heard and what they personally saw. That's it. Now, witnesses were interviewed. The defendant himself gave a statement, as I mentioned. He gave a tape statement. What the evidence will show you is that Chad Olson was shot and killed over tossing popcorn. The defendant's statements are fairly consistent with other testimony and other evidence, including the video, up until the point of time of the shooting. The evidence will show you that the defendant's statement is not accurate as about what had occurred, based on what you're going to view during the course of this trial. So what did the defendant tell the police? The defendant tells the police that he went to the theater. Obviously, he did. While he was in the theater, he saw Chad Olson had his phone on. Now, the defendant states he leaned forward and was being nice, asking him to turn the phone off. When Chad Olson did not, he got up and he went to tell the manager. He came back. The defendant says that when he came back, he did talk to Chad Olson, and he told him the statement that I represented before. I see you're not on your phone anymore. I went to tell the manager. He says, and again, the words he chooses are very important. You're going to learn that he was former law enforcement, so he knows the importance of the accuracy of words. He says that Chad turns around in his seat, and at that time, there's some words between them. He then indicates that Chad Olson jumps up. Now, here's where I submit to you the tape statement has maybe two different statements, and this is where you're going to have to critically analyze this tape statement. It seems as though the evidence will show you that the defendant states nothing at all about the popcorn in the beginning, as that event never took place. Now, you're going to learn with his glasses on, the defendant's got 20/20 vision. Can't really miss anything. What the defendant states is that Chad Olson is coming over on top of him. Okay? So when you listen to the tape statement, at first it appears as though the whole popcorn thing never happened. Later in the tape statement, the defendant states when Chad Olson jumped up, the popcorn fell almost immediately. Well, the evidence is going to show you that after the popcorn fell, that's when this defendant immediately took out his firearm and killed Chad Olson. So the evidence will show you that tape statement's not exactly true. He says that when Chad Olson jumps up, the popcorn fell immediately, and this is the picture painted in the defendant's tape statement. Here's what the evidence will show you. The defendant states he's in his seat. Behind Nicole Olson, remember, Chad Olson's one seat over to the right. One row down, one seat over. He's back in his seat, and he's got his left hand up, and he's yelling, no, 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 or whoa, whoa, whoa. This is the picture the defendant's going to paint on this tape statement. And he's back in his seat, and Chad Olson is coming over the seat, and Chad Olson is virtually on top of him. In his lap. Those are the words the defendant himself uses. Virtually on top of him, in his lap, and he's got his left arm out, and he's touching his arm or his shoulder, but he really believes he's touching Chad Olson's chest because he's so far into him, into his row. And at that time, he has to straighten his right leg out, pull out that firearm, and kill him. The defendant states he's surprised he didn't shoot his left hand because his left hand was so far out when he took that shot. He's surprised. The evidence will show you that is not exactly what happened. There will be no witnesses that will come in here and tell you that happened. No one heard any yelling, screaming, any type of fight like that, life or death struggle. You're going to hear about a term called stippling during the course of this trial. Stippling, and this might be a really bad description of it, is when a firearm is fired, material comes out, hot material, and anything that's close in its way gets these embers, so to speak, and there's a burn mark on skin. Now, you will see stippling in this case. The evidence will show you there was stippling on Nicole Olson's hand because it was in front of the firearm when her finger was almost shot off. You're going to see stippling on Chad Olson's wrist because when he brought his wrist back after tossing that popcorn, you're going to see stippling all over there. But the evidence is going to show you there's no stippling on the defendant's left hand. The evidence will show you that's because his left hand was not out. No, 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 you got to get off of me. That's what the evidence is going to show you. Now, after the defendant fires the shot, there's some important words that people in the theater hear. And these are people that don't know each other, and these are people that are in different areas of the theater. And the defendant states some words to the effect of throw popcorn at me or throw popcorn on my face. Yet when you listen to the defendant's taped statement, it never really brings up the popcorn. The evidence will show you that's important for ill will and spite. And when you see the way he lunges forward with the firearm and makes that statement, you get a clearer picture of what was really going on in the theater on January 13th. The defendant states in this taped statement that while he's back with his arm out yelling, no, 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 or whoa, 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 and Chad's virtually in his lap, he's struck on the left side of his face. Remember, you can hear defendant, prior law enforcement. Words and choices of words are important. The defendant states in this taped statement that he's hit on the left side of his face. Well, witnesses are going to tell you they never saw that. And the evidence will show you that almost scientifically, physically, it's not possible. Because the evidence will show you that Chad Olson was a row in front and a seat over to the right. And that it would be virtually impossible for him to do this hook that hooked all the way around from that distance across an aisle, all the way across seats, and struck the left side of the defendant as he was all the way back with his left hand out. The evidence will show you that simply did not happen. The evidence will show you there was no injury, as if he was struck that hard, because the defendant in his taped statement, you will learn, says he was dazed. But he wears glasses. You will see there is no injuries of any markings for glasses of being hit that hard that he felt he had to kill another human being. At some point in the taped statement, the defendant indicates he thinks that maybe a cell phone was at play because he saw the blur of a screen. Now, you will learn that a cell phone was found in front of the defendant, and it was, in fact, Chad Olson's cell phone. I submit the evidence will show you that it got there in one of two ways. One, because he was holding it in his left hand or his left side, and we know that because that was the side that was bothering the defendant, that when he stood up and he grabbed that popcorn, it fell over. Or at the time he...
Rosenwasser is going through the case with the jury here in the opening statement for the state of Florida. We'll step aside, take a break, and return right after this.
Hi, I'm Mark from the Medicare Helpline. If you're on Medicare, it's time to call to see if you're getting all the Medicare benefits that may be available to you, even if you called last year. Many Americans may be eligible for additional benefits. Your zip code may qualify you for a Part B give-back benefit in your monthly Social Security check. So, call to see if you're eligible for a plan that may include additional benefits. You won't get additional benefits automatically, but listen. I'm here to tell everyone on Medicare it's fast and easy to check up on your Medicare plan benefits.
to the defendant being hit with that phone, and there's no possible way that could happen. Now, another stipulation will be about this cell phone. This cell phone was also sent to the Florida Department of Law Enforcement. And there was some DNA testing done on this phone. Chad Olson's DNA was on the phone, but not the defendant's. Now, you're going to see pictures. The defendant did have some redness on his left eyelid, possibly the most fragile part of the human body. But the evidence will show you he had his glasses on, and the reason that his left eyelid, only his left eyelid, was red was because after the shooting, he was rubbing his face and rubbing his eyes, and witnesses will tell you that. He indicates he thinks there's something in his left eye. Paramedics check him out. There's nothing in there. They do a saline rinse. That's the end of the story. The defendant indicates in his taped statement that he second-guessed himself. He's sitting in the cruiser, and you're going to hear he says, "I'm second-guessing myself. Did he hit me?" This is the picture that's going to be painted for you during the course of this trial. The defendant also states, and I apologize for cursing, at some point in his taped statement, now, for his actions, the defendant's been charged with 2 crimes: murder in the second degree and aggravated battery. Now, again, all of the jury instructions are going to be explained to you at the conclusion of the case. Now, suffice to say, this is what murder in the second degree is. What we have to prove to you is Chad Olson is dead. It was due to the criminal act of the defendant, and it was by an act that was imminently dangerous to another, demonstrating a depraved mind. Shooting someone at close range is an act imminently dangerous to another. That's not going to be an issue in this case. Did he do it with a depraved mind? That's where we fall back on the definitions that you're going to learn: ill will, hatred, spite, or evil intent. The other crime that the defendant's been charged with is aggravated battery. Now, going back to murder in the second degree, we do not have to prove to you that the defendant here intended to kill Chad Olson, just that he intended the act, which he did. This is not a case where it's an accidental shooting. He did intend to shoot him, and he died. We just don't have to prove he intended to cause Chad Olson's death. Now, aggravated battery, what we have to prove to you is that the defendant did intentionally, knowingly, and unlawfully touch or strike Nicole Olson against her will. Now, obviously, he didn't do that with his hands. He did that by using a gun and firing a bullet. So it's the same analogy. Did he touch or strike her against her will? And did he use a deadly weapon? Yes, a firearm is a deadly weapon. The other way that we could prove aggravated battery on Nicole Olson is, did he intentionally touch or strike her against her will? Yes. And cause great bodily harm, permanent disfigurement, or permanent disability? And the answer is going to be yes. You're also going to learn about an instruction called transferred intent. And basically what that means is if one person intended to do an act, meaning the defendant intended to do an act to one person, but ended up harming another. In other words, intending to shoot Chad Olson, but harmed Nicole Olson, be transferred intent. And that's how we get to the aggravated battery charge. Now, what is this case going to be about? Based on the facts that you were given at the beginning and during jury selection and the defendant's own taped statement, it's apparent the defendant is claiming self-defense. So you're going to hear a lot about self-defense. At the conclusion of the case, you're going to get all of the self-defense jury instructions. The question will be not whether or not this was an accident, because there's no evidence of that. It was an intentional shooting. Whether or not the defendant was lawful, whether or not he was justified in using that deadly force and killing Chad Olson. Now, this is basically what the self-defense instruction indicates. The use of deadly force is justifiable if Curtis Reeves reasonably, okay, and these are going to be important words here, reasonably believed that the force was necessary to prevent imminent death, he was going to die, or suffer great bodily harm, while resisting an attempt to commit a felony upon him. In deciding whether or not the defendant was justified in the use of force, the use of deadly force, You must judge him by the circumstances by which he was surrounded at the time the force was used. The evidence will show you those circumstances at the time that the force, meaning the shooting, took place, was that another individual had tossed popcorn on him. The danger facing the defendant need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person under those same circumstances would have believed that the danger, and the evidence will show you the danger was popcorn was just thrown on him, could be avoided only through the use of that force. So the question for you will be this: would a reasonably cautious and prudent person that's 71 years old, because that's how old the defendant was, would a reasonably cautious and prudent person that's 71 years old, 6'2", 270 pounds, who's able to walk all around the movie theater, who has over 20 years of law enforcement experience, including 15 years on the Special Weapons and Tactics Squad, also known as SWAT, sitting inside a theater that by all accounts is going to be described as one in which you can see the environment, not pitch black like the movies, and not deafening loud, reasonably believe that the danger could only have been avoided through the use of shooting Chad Olson? And the answer is going to be absolutely not. The evidence will show you there were some differences between Chad Olson and this defendant on January 13th of 2014. Chad Olson was 6'4", the defendant here is just 6'2", 2 inches difference. The defendant outweighed Chad by 65 pounds, but there was an age difference. The defendant was sitting an entire row back, an entire seat over. But the most important difference you're going to learn about during the course of this trial is that one of those two individuals brought a loaded firearm into a theater and shot and killed another person after popcorn was tossed on them. And that's this defendant. That's the one. At the conclusion of this case, we're going to ask you to find the defendant guilty of murder in the second degree. And we're going to ask you to find him guilty of aggravated battery. Not because we're asking you so, but because the evidence that you're going to see and hear during the course of this trial is going to tell you that that is the lawful and just verdict in this case. Thank you.
Thank you, Mr. Rosenwasser. Ladies and gentlemen, who's going to... Okay, we're going to take a break, yeah. Mr. Michaels will be doing his opening statement in a few moments, but I think it's appropriate to take a 10-minute recess.
All right, they're going to take a break there. That was the opening statement from the state of Florida. Let's slip in a break here and talk about what we just heard.
I'm Vinny Politan. Welcome to Closing Arguments. There will be names you know and others you will soon know. All year long, we've been on top of this story. This is the most polarizing case I have covered.
This was a complicated case for these jurors.
There is so much on the line, so much at stake.
We had the facts, and we knew we had the law on our side.
But what was this case really about?
Closing Arguments with Vinny Politan. Tonight at 8/7 Central. Only on Court TV.
Man, drive time makes it easy to buy a car. You can pretty much do it all on your phone and your own time. I got approved, found tons of cars.
disability benefits but were denied. Don't wait. Call the number on your screen now to get the help and benefits you deserve.
Call 800-645-0149.
Welcome back. 8 years ago, Chad Olson, 43-year-old man, threw popcorn at 71-year-old Curtis Reeves. Olson ended up dead. Reeves now is a defendant. The trial is in a brief recess this morning. Before the opening statements, the attorneys argued at length about a grainy surveillance video of what happened in that movie theater, and then it was time for the openings, and the prosecution was first. Assistant District Attorney Scott Rosenwasser addressed jurors. Here's how he previewed the state's case.
Now, what are you going to learn? Well, people are going to tell you what the lighting environment was. So people in the theater are going to tell you the following. Now, don't pay particular attention to any single one-word description, because you can't adequately describe something in one word. In other words, to be pigeonholed to one word. For example, in everyday life, if someone were to tell you that someone was of a medium build, well, one person might think of that as a thin person, and another person might think of that person as a heavier person. But the description, when people elaborate, that's how you're going to be able to determine exactly what happened. So in this case, what are you going to hear from people that were in the movie theater? You're going to hear that at the time of the previews, now, this shooting occurred during the time of the previews. So when I talk about the lighting conditions, it's the same during the time of the shooting. So what witnesses are going to tell you is that it was light enough for them to see in the movie theater. The lights weren't full, they weren't full house lights. It had been dimmed. So if you hear the words dim, dimmer, pretty dark, darker, that sounds like it's painting a different picture. But I submit the evidence is going to show you that when everyone came into the theater, their overall description, forget the one word, was that they could see. They could see aisles, they could see rows. They could see seats. They could see people in those seats, even at a distance.
All right, let's bring in criminal defense attorneys Andrew Mishlev in Milwaukee, Wisconsin, and Nicole DeWard is in Houston, Texas, watching along with us and joining our conversation. Good morning, Nicole, and welcome. What'd you think?
I thought that the prosecution did an outstanding job of laying out exactly what their case was going to be in detail, what we could expect to hear, and why the defensive theories would fail in their opinion. So I think that they've done an outstanding job so far.
Andrew, not a lot of, no PowerPoint, no media. It was very basic, but to Nicole's point, easy to follow. Your thoughts?
I thought it was an excellent opening statement. Facts drive the narrative. This attorney, Mr. Rosenwasser, did not just argue opinions or try to convince the jury to believe things because he wanted them to believe them. He laid out very specific, detailed facts that drive them to those conclusions. The fact that it was Reeves' popcorn that was flipped at him. He started out by saying, don't believe it when people say it was dark, which probably isn't that persuasive. But then he went on to say it was during the previews. The house lights weren't fully down yet. So it's these little facts that drive the narrative. And I agree with Nicole. He put together a scene, detail-filled, rich. The jurors could feel themselves and see themselves in the theater. And it was a very powerful presentation of Curtis Reeves as a hothead.
That's so now we await the defense opening statement. The judge is on the bench, jury not back in the courtroom. Let's go in there discussing something.
Stipulations, when lawyers agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated fact, or at the moment, well, right now, that's the same ringtone that my husband uses from me. Gets my attention. Okay, so I'm going to read that instruction, then I'll read the stipulation.
All right. Thank you,
All right, they are just going over some stipulations that they're going to read along with an instruction when the jury gets back into the courtroom. And then it will be time for the opening from the defense. Nicole, what does the defense have to do here? What are you going to be listening for?
The defense has got to neutralize some of what the prosecution has said. The prosecution has made this sound like, again, that the defendant was very much a hothead and that he was overreacting to what would ordinarily not be seen as something that would require someone to use any sort of self-defense. And the defense is going to have to really put us in the defendant's shoes as to why his conduct should be perceived as reasonable from a self-defense perspective.
Andrew, does it matter about an outsider's view of what happened? Because it's ridiculous from an outsider's point of view. You get popcorn thrown at you, pull out your gun and shoot someone. Does it, or is the key thing here what was going on in his head, the mens rea, what he thought? Did he feel he was being threatened?
It's not just whether he felt he was being threatened, Ted, but whether the jurors can put themselves in his position as a reasonable person. So the challenge for the defense here is to try to get the jurors to see it from Curtis Reeves' perspective, and that perspective has to be one of a frightened elderly man as opposed to a hothead with a gun in his pocket. They're going to have to challenge very specific facts. Such as the statements he made afterwards. Throw popcorn at me, will you? Which, according to the prosecution, several witnesses heard. Those facts are very damaging, and Reeves' attorney is going to have to neutralize them somehow, some way.
Yeah, that's a damning statement, and you had pointed out that we should be looking for it in the open, and there it was. As we see, the attorney is just looking over the equipment. There's always equipment malfunctions in courtrooms, especially on day one when the jury is there. They're trying to prohibit make sure that doesn't happen. So everybody looking at what the defense is going to bring out in the open. And Nicole, it looks like this will be a multimedia type of open from the defense. Sometimes that can go a long way.
It really can. I mean, so really people learn in different ways. Some people learn by hearing things. Some people learn by seeing things. And some people learn kinesthetically, which means that they feel the emotion of what's happening. And so a good opening statement will employ all of these different ways that people might learn: visual, auditory, and kinesthetics, so that the jurors who are different, each of them potentially, in the way that they receive information will actually remember it and it will resonate with them. So it can be a helpful thing to do to have these different visual aids during an opening statement.
Yeah, absolutely. Andrew Mishlev, we want to thank you for your time this morning and your expert opinion and helping us guide through all of this. We're going to slip in a break here while they work out the kinks in the courtroom there, and then when we come back, we will hear from the defense the opening statement, the always important opening statement from the defense representing Curtis Reeves. That when we return. This is Court TV, your front row seat to justice. Stay with us.
Big George Foreman here, and if you're on Medicare like me, listen to this.
You may qualify for a plan with additional Medicare benefits in 2022. Did you know that depending on your zip code, you may be eligible for a plan with the Part B Give Back benefit that may reduce your Part B premium deductions from your Social Security every month? Call the toll-free number on your screen to see if you qualify for a plan with additional Medicare benefits. Just call 800-806-8268 now.
I just couldn't believe that there's even a benefit that can add money back to your Social Security check every month based on your zip.
Continuing coverage of the state of Florida versus Curtis Reeves. After 8 years of delays and some heated jury selection that went 4 days, the trial of a former cop, Curtis Reeves, currently underway. 79 years old. He faces charges of second-degree murder and aggravated murder for the shooting death of Chad Olson back in January of 2014. Jurors will now be tasked with deciding if Reeves was reasonably scared for his life and acted in self-defense when he shot Olson in a movie theater after the two got into an argument over cell phone usage. The trial of Curtis Reeves has been years in the making, made national headlines, and the defendant's claims of self-defense. He tried originally to get it into the stand your ground laws, and that didn't work out for him. Here's Julie Grant.
It's been years since a cell phone, popcorn, and a pistol permanently changed the lives of a small family in suburban Tampa, Florida. Chad Olson loved spending time with his wife, Nicole, and their 22-month-old baby girl, Alexis. Friends and family say Olson was a genuine, funny, go-getter type of guy. On January 13th, 2014, Chad and Nicole Olson were sitting in a theater waiting for a movie to start. And as the previews were rolling, Chad was on his phone, texting their babysitter to check on baby Alexis. This security video shows the man sitting behind them, Curtis Reeves, objecting to Chad using his phone, and the two start arguing. Then Reeves went to complain to the management. Here's Nicole Olson recalling Reeves' demeanor that night.
I see you've put your phone away now that I went to get management. I remember feeling this should have been over. He's got what he wanted. Why is he still doing the, haha, you did what I told you, I won? That's kind of how it felt to me.
Witnesses told police that the argument continued when Reeves returned to his seat. In a recorded audio police interview, Nicole describes what happened next.
My husband said, dude, what's your problem? You know, I wasn't making any noise. The movie hasn't even started, and that's all I remember.
Then the argument went from loud to lethal. Reeves, a retired Tampa police captain, claims he feared for his life after Nicole's husband threw a bag of popcorn at him. In his police interview, Reeves said Olson stood up and hit him in the face with an unknown object. Let's watch that again, slowed down. You can see what looks like Olson's arm make a very quick motion toward Reeves. Here's how Reeves remembers the incident.
Get out of my face. I'm leaning all the way back in my chair as far as I can to get away from him, and suddenly he's virtually on top of me. And I think I'm saying either no, 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 or whoa, whoa, whoa. Suddenly my head was to the right, so he hit me with something.
And that's when Reeves pulled his pistol from his pocket and fired one shot at Olson.
I did not see him pull it out, and I did not see him shoot it. I just saw the spark and heard the noise.
43-year-old Chad Olson was taken to the hospital where he later died. Curtis Reeves was charged with second-degree murder. He says he shot in self-defense. At a hearing in 2017, Reeves' attorney tried to prove that this was a stand-your-ground case. The controversial Florida law allows people to use deadly force when they fear death or personal bodily harm.
A 6'4" individual standing, trying to come over that chair is terrifying.
But the judge ruled that the stand-your-ground defense does not apply in this case.
If I had it to do over again, it would never have happened.
Now, Curtis Reeves is set to go on trial for second-degree murder.
And that trial, of course, starting today with the opening statements we heard from the state. Now it's up to the defense. The judge has called for the jury. They've worked out their technical issues. We're just waiting for the jury to come back in. Nicole DeBoard is watching along with us. Again, Nicole, here's the chance for the defense. How important is this in terms of laying out your case and getting jurors to think about your side of the story as the state presents its case?
Opening statement is incredibly important. It really tells the jury the evidence that they are about to hear, and it gives the defense an opportunity, especially to have jurors thinking critically about things that the state or the government is going to bring, because the state goes first. So they're going to be bringing their version of the facts forward, and what the defense is going to hope to do by giving their opening statement is say, look, when you hear this next piece of evidence, think about it from this different perspective. So it is important.
Absolutely. All right, the judge is talking to the jury, getting ready for the defense open. Let's go in live.
then in just a moment, I believe Mr. Michaels will begin his opening statement.
Thank you, Your Honor.
Thank you.
Your Honor, may I reposition myself?
You may.
Before I begin my opening statement, I'm going to request of the court, Your Honor, if you would please read the stipulation concerning the DNA evidence in this case on the cell phone case and screen.
All right. And ladies and gentlemen, when lawyers agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated facts that you must accept as true are as follows. The state and the defense stipulate to the following facts. The iPhone belonging to Chad Olson, which was seized by law enforcement on January 13, 2014 from inside Theater Number 10, Cobb Theater at the Grove in Wesley Chapel, was tested by Mary Pacheco of the Florida Department of Law Enforcement Biology Unit for the presence of DNA material. The testimony of Mary Pacheco would establish the following results. 1, the DNA profile obtained from the iPhone black case, Exhibit AP13, demonstrated the presence of a mixture of at least 3 individuals. Due to the complexity of the mixture obtained from the iPhone black case, this data was not interpretable. Number 2, due to the limited nature of the DNA results obtained from the iPhone's black case screen, this data is insufficient for inclusion purposes, but may be suitable for exclusion. Number 3, due to the limited nature of the results obtained, Chad Olson can be neither included nor excluded as a contributor to the iPhone's black case screen. And number 4, Curtis Reeves is excluded as a source of the limited DNA results obtained from the iPhone's black case screen.
Thank you. Mr. Funderburk, bring up the display, please. Thank you. Okay, let's look at this. And why did I bring this up to start my opening statement? I brought this up because I want you to be able to put into context, to look at the form of the information you're getting from the prosecutor right off the bat in opening statement. What the prosecutor told you is simply not true. There is no stipulation, there is no evidence that the cell phone case or the cell phone case screen had the DNA of Chad Olson on it. It's just not true. Let's look at this. It says, as the court read, DNA profile from the iPhone case. This is an iPhone case, black case that has a white cell phone in, a white iPhone. It's a case that has one of those screens that's kind of attached to the front for protection. So when they talk about the case, they're talking about the outside. When they're talking about the screen, they're talking about the front of the screen that a person would kind of scroll on. And so what this says is that, number 1, presence of a mixture of at least 3 individuals. Due to the complexity of the mixture obtained from the iPhone black case, data was not interpretable. So based on what they got from the case, they couldn't interpret it. They have at least 3 people on it. So is it possible that if the evidence was properly preserved, that we would see Mr. Reeves's DNA, Curtis Reeves's DNA on that case as it hit him in the head? Of course it's possible. We'll never know because the way that this phone was handled was abominable. The sheriff's office didn't go in there and try to preserve it for any DNA evidence. They had a tech pick it up, manipulate the phone. Later on, they pull it out of a room again and try to turn it on to see whose it was, even though they knew who it was, who it belonged to. Due to the limited nature of DNA results obtained from the iPhone's black case screen, the front of it, this data is insufficient for inclusion purposes, but may be suitable for exclusion. Again, that doesn't tell you that Chad Olson's DNA was on the phone. It tells you they can't tell you whose DNA was on the phone. Next page, please. Due to the limited nature of results obtained, Chad Olson can be neither included nor excluded as a contributor to the black case screen. So what they're telling you is, not as the prosecutor told you, the evidence will show with a stipulation that, not true. That phone does not come back with Chad Olson's DNA. We know it's his phone. His wife said, that's my husband's phone. The prosecutor and the state attorney's office and the sheriff's office, they all went in the phone. We know it's Chad Olson's phone. But there's no DNA evidence that says his DNA was on it. It says Curtis Reeves is excluded as a source from the screen. That's all it says. So if a phone is going through the air, there are two sides to it, there are corners to it, the screen hits Mr. Reeves. Maybe. What if the back hits Mr. Reeves? Then certainly this isn't something that would be unusual. Not unusual. And so I bring this up to you because I think that it's important. That's only one thing. I think it's important that you realize what it is you're being told here. From off the bat, you're told there's DNA on the phone. The other thing you're told, and you're going to see photos of it this morning, he's all the way in the other row. Chad Olson is a whole row away from Mr. Reeves. Chad Olson is a whole seat over from Mr. Reeves. You're going to see how very close they were. The theme of the prosecutor's case that this was over popcorn. And what the prosecutor told you going in is, well, all I have to prove is that someone was shot, somebody died as a result of that shot, and their state of mind regarding that. That's not true. What the prosecutor has to prove, what the government has to prove, what the state of Florida has to prove in this case, beyond a reasonable doubt, that this was not justifiable. And when they talk about justifiable, the prosecutor told you, frankly, that's the law of circumstances. Under the same circumstances as Curtis Reeves, knowing what he knew, you're going to decide if it's reasonable if you were trained like Curtis Reeves. You're going to decide if it's reasonable if you're 71 years old. And although the prosecutor is telling you he walked all right, he did all this and that, you're going to hear from experts. And I'm going to talk to you a little bit more about that, about what the realities of the aging process are and what the realities of Curtis Reeves's condition was. So the framework of what you're to decide, the states that I'm going to ask you to come back, I can't ask you how to decide the case. You're the jury. You look at the evidence, and that evidence has to measure up beyond the exclusion of every reasonable doubt that Curtis Reeves did not act justifiably in protecting himself and protecting his wife who's sitting next to him. So since we're talking about Curtis Reeves and stepping to his shoes, let's think about that for a second. Number one, he's in a theater. The prosecutor's trying to make it seem, the same way they tried to make it seem about the DNA, that this theater is somehow lighted so you can see everything. A lighted movie theater with the previews on, imagine. They're telling you, don't believe. If somebody comes up with a description in one word, don't believe. No one can tell you what to believe and what not to believe. Their job is to put on the evidence, and you believe or don't believe. You're convinced by their evidence. Not because they're putting parameters on you, they're giving you rules. Don't believe this. If you hear one word, that's not true. Listen to the testimony, which you will. Let's talk about Mr. Reeves. All right. 27-year police veteran. Served his community for 27 years at the Tampa Police Department. Highly decorated officer. none more decorated in his years there. They thought so highly of him that at one point, the powers that be with Tampa Police Department came to Curtis Reeves and said, "We want you to start a SWAT team here," which he did. A responsibility he took very seriously, because that responsibility, that is a responsibility with other people's lives, his men's lives. And so he became trained, and he trained his men. He trained his men so that every day they could come home to their family. They can go home to their family and be safe. That's the training of the man that was in the theater with his wife. He was a superstar. And when he was there, he did everything from patrol as a young man to homicide detective and everything in between. So he saw what it was like out there. He knows about danger. He knows what a fist can do to somebody as a young person or an old person. And by the way, the state's telling you, well, he's preventing great bodily harm. You're going to get a definition of that. That means something more than a bruise. It's not a bruise. That's what the judge is going to tell you. That's the law. After 27 years, the Tampa Police Department, Curtis Reeves is so highly thought of. When he retires from the police department, he gets recruited by Bush Entertainment, Busch Gardens, becomes their head of security. Now he's kind of in a job where he's dealing with the entertainment industry, the pleasure of the experience in the park industry, and he receives training for that. And you're going to see, we're going to talk about it in a little bit, some of the various courses he took. You're going to see a list of courses, and we'll talk about some of them. So throughout his years, he certainly learned how to assess a risk. He certainly knows how to spot danger. And so when he's in that theater, it's no different. That's his training and experience. That's something that you must consider before you make a decision, whether it was reasonable or not. And is this over popcorn? It is not. I'm going to show you some videos. And you're going to see that the prosecutor tries to paint this picture. They said Mr. Reeves is trying to paint a picture. By the way, he's a law officer. He should have known better. When he got arrested, he talked to them and he knew the words to use. Well, if he's a law enforcement officer, he also knows he has a Fifth Amendment right not to speak to the police. And he could remain silent and call his lawyer right away, but he didn't. So let's just talk about the fact that he's in a movie theater and they're saying it's over popcorn. You're going to see there was an attack before the popcorn was thrown. I'm going to show it to you. It wasn't just one attack, and it wasn't just popcorn being thrown. Put yourself in Mr. Reeves' seat. This is kind of a very unique situation in criminal law, because as jurors, you have to kind of put yourself in his shoes. After working at Busch Gardens, his body starts to break down a little more, continuing to break down, and he retired. Just couldn't do the job.
All right, we need to slip in a break. Opening statement from the defense. We'll pick it up right where we left off.
Retired police captain Curtis Reeves awaits trial after fatally shooting a man in a movie theater.
Throw popcorn on me, will you? Bang!
He claims he acted in self-defense.
A 6'4" individual standing, trying to come over that chair is terrifying.
But does thrown popcorn justify using lethal force?
The movie Popcorn Murder Trial. Live coverage today on Court TV.
I have type 2 diabetes. I've pricked my finger too many times. My A1C
Matthew, who is a police officer with Tampa following in his father's footsteps. Jennifer Shaw, she's the daughter of Curtis and Vivian Reeves, and she has a child, their only grandchild. So Curtis and Vivian Reeves settle into retirement. They build a big house because they're hoping for a lot of grandchildren. They want to have room to entertain. And they decide to go to a movie on January the 13th, 2014. As you know, lone survivor. As he walks in, let's think about this 71-year-old man. The prosecutor's saying, well, he's 130 yards of football in the third away, football field in the third, I guess not counting the end zones, football field in a third away, and he walks there just fine. Doesn't use a cane, doesn't use a walker. You're going to hear from several witnesses. They're going to tell you about his physical condition. You're going to hear from Matthew, his son. Matthew's going to tell you about his father, a robust, vigorous man, as he sees them over the years being able to do less and less. Can't leather work, can't do woodworking, has trouble with his hands. They went on a hunting trip right before the movie, and Curtis Reeves couldn't pull back the compound bow. They were looking to getting him a crossbow. So he's seen his father deteriorate over the years. He knows that his father calls him up, Matt, I need the leaves taken off of the patio screen in the back. Jennifer, his daughter, is likewise going to testify how she's seen her father over the years deteriorate. She's seen him at one point, again, outdoors, going hunting, going fishing, camping, to a point where he can't take apart the paddles for a kayak. To the point where when he's on the floor playing with her daughter, with his granddaughter, he can't get up without help. Vivian Reeves is going to testify too. Now, she has her own health problems. She probably has ailments that are very serious. In fact, I know she has ailments that are very serious. She's going to tell you about them. She's being treated at Moffitt at the time. She had a knee replacement. Not in the greatest of shape. At any rate, she's going to tell you how she's seen the changes in her husband as well. How he needs to push himself off of the chair to get up when they're watching television. A little thing to some of us. Very important in this case. In fact, she's going to tell you that the day they were in the movie theater, the shoes that he was wearing, that Curtis Reeves was wearing, you didn't have to tie him with your hands because he had problems tying his own shoes. That little thing you pull, like you put on a preschooler, so they can tie their own shoes. You're going to hear from Dr. Donna Cohen. She's a PhD. She's a leading authority in the field of aging and the process of aging. She headed up the aging studies in University of South Florida. In fact, she started it. She's been doing it for over 50 years. She's an educator. She's going to testify as an expert. She's going to testify as an expert in the field of aging, the process of aging, and how it affects one's vulnerability. Because we can all think, well, he's walking all right, but really what's going on in his head? Police training, realization of vulnerability, it's important. We take for granted that we know about getting older. She's going to tell you scientifically, as an educator, how that works and why that works. You're going to hear from Dr. Michael Foley. He's a radiologist, a preeminent, nationally known radiologist. Why? Because the prosecutor's telling you, look at him, he can walk. You're going to see his x-rays and his MRI. And that radiologist is going to tell you about all the degenerative processes, the breaking down of his body that you can see on the x-ray. So he looks all right on the inside, on the outside, but not so good on the inside. He's got problems with his neck, his back, his shoulders, his hands, his hips, osteoporosis in his hips, all the way down. And so what does that do to an individual? Makes them more vulnerable. Also, it makes them more vulnerable to serious injury. So in that regard, you're going to hear from Dr. Bernard Adams. He's a pathologist. He used to be the medical examiner for Hillsborough County for 20 years, and now he's a pathologist on his own, and he's going to testify as an expert. The interesting thing about Dr. Adams, what he's going to do is he's going to show you on a model the most vulnerable part, starting off with the most vulnerable part of a human body is the head. So he's going to show you why it's vulnerable. He's going to tell you about older people. As you age, your brain shrinks, leaves more room in the skull, which makes you more prone to injury if you were to get a blow in the head, to the head. He's going to show you the changes in the bone structure of the neck, of the rib cage, that again make an older person, a person as they age, more vulnerable to serious bodily injury, to great bodily harm. He's going to talk about the fist as a weapon, the anatomy of it, how when you close your hand, it forms these points, your knuckles, and that becomes a dangerous weapon. You heard a little bit about what Curtis Reeves said. He got hit. He did. He has a red mark on his eye. The prosecutor's telling you somehow magically the phone flew around, this and that. Well, if it was so well lighted, you can see it on the video, why didn't everybody else see that happening? Why didn't everybody else see the popcorn grab? Because it was a dark theater. And the video, by the way, since I'm here, we're going to talk a little bit about the video. That system is not very good. It captures, it's infrared, it's motion detecting of a sort, so you're not going to see a clear video. In fact, our expert, Bruce Koenig, who again is a nationally renowned expert, he worked on the Monica Lewinsky case. They actually had him look over the JFK tapes again. He worked for the FBI, headed up their audio and visual department. He's still out there testifying as an expert. He will tell you about the resolution, how bad it is. I don't have it in front of me, so I don't want to give you the wrong numbers, but the numbers compared to what the iPhone was at the time, the iPhone had like 600 pixels, and this had like maybe 12,000, something crazy. And so you're going to see, you'll get a little piece of it today, a video that doesn't really give you good quality and doesn't show you everything. We would hope that it showed you. Let's talk about the facts of the case. You heard the prosecutor. Mr. and Mrs. Reeves.
All right, we're going to push pause here. You won't miss a thing. We'll pick up the rest of the defense opening statement when we return. Stay with us.
eHealth's Busting Medicare Myths program is here today in Tampa, Florida, where a group of local seniors has gathered to learn the truth about their Medicare options and get straight answers to their important questions. What is the first big Medicare myth that people believe?
The first myth is one that everyone wants to believe, and that is Medicare is free health insurance. Busted. Here's the truth. Those Medicare deductions you paid during your working years were simply applied to the monthly premium for Medicare Part A, which is only hospital insurance. There's still
quiet around you and be able to enjoy the experience of watching a movie in a movie theater. The plan is to meet their son, Matthew, there, the Tampa Police Department police officer. He's washing his truck, so he's a little late. He's going to meet them there. They walk in. As the prosecutor told you, it's true. That's true. They paid for his ticket. He walked in. They got a cold drink and a popcorn, which they share. Miss Vivian Reeves brings a little plastic baggie. Curtis Reeves gives her half the popcorn so they can each have their own. And they walk into the theater. Before they walk into the theater, Mrs. Reeves goes to the restroom. Now they walk into Theater 10. That's true. It is Theater 10. They walk into the theater. They're looking for 5 seats together. Why 5? Because they want to put their son together with mom and dad and have 2 seats, one on either side. And so they look, they see 5 seats together at the very back row. The very back row, as you were told, is the row that abuts what's called the Cine Bistro. There's a wall that's about 5 feet tall. Prosecutor told you about that, but an interesting fact about that wall is the chairs in the theater, they move back. They recline back slightly. You can't lay down, but they recline back. With that wall behind the seat, you're not going to get as much movement on them. So Mr. Reeves sat there. Curtis Reeves, his wife, directly in front of Curtis Reeves. Already there is Nicole Olson. Directly in front of Vivian Reeves is Chad Olson. Now the prosecutor's telling you it's a whole row away. You'll see how close those seats are. They sit down to enjoy the movie. Curtis Reeves notices the phone is on. Yeah, he's not talking, but there's a white light. Prosecutor, there's a white light coming from the phone. We know he was on the phone. We know he was on Facebook. Doesn't matter if he was talking or not. There's a white light coming from the phone, and it's in Curtis Reeves' face. He asks him politely, would you please put the phone away? The answer he gets is, I will. You're retired. You're with your wife who's retired. You're there to have a movie experience. You ask somebody to put their phone away, and the response isn't bug off. The right thing. He gets up. He's going to tell the manager. At this point, there is no thought that this person is going to turn into some hostile force, which happens later. At this point, it's just a loud guy who's cussing and ruining everybody's movie experience, including mine. Curtis Reeves walks down the aisle. Some people are saying he mumbled. They'll tell you, I don't know if he was telling his wife, I'll be right back. They don't know what he was saying. Some people don't hear the mumbling. Certainly he didn't kick anybody. He didn't hit anybody. You'll see the video for yourself. In fact, when I finish, I'm going to show you that part of the video. You hear from the prosecutor how he can just walk down the aisle. It's not a problem. It's really close. Watch the video. This is what you're going to see. I guarantee this is what you're going to see. As Curtis Reeves walks down the aisle, he has his hand up, and he's touching the wall for balance. You'll see him do it. He goes out to the desk, the service desk. The manager's there, a fellow named Thomas Peck. He's talking to this woman, Dawn Michelle Simpson. If the prosecutor doesn't call her, we will. She's there talking to the manager, telling him that she wants some movie posters to decorate her house or her TV room, some sort of thing like that. Mr. Reeves just waits. He doesn't interrupt her. He's not rude, and that's a testimony you can hear. You can hear the testimony from Dawn Michelle Simpson. You're going to hear the testimony from Thomas Peck that Mr. Reeves was polite and acted very nicely to please help me enjoy this movie experience I came for. Those aren't the words, but you get the idea. Mr. Reeves walks back into the theater. And I understand what the prosecutor's saying. The prosecutor's saying, well, He says in his statement that he initiated contact. Well, think about that statement. Here you have somebody who at this point is a suspect in committing a crime, not because it's a whodunit, as the prosecutor rightfully said. It should have been because the detective should have been thinking, was this a justifiable use of force? Never entered his mind. So they have Curtis Reeves sitting there, and they don't ask him these questions. They don't go back and re-interview him. So it's all right for witnesses that are going to be pro-government or say something that the state wants them to say, and you to believe them.
I'm going to object to that. That's argumentative. It's not appropriate for us.
All right. I'll sustain. Move on.
The evidence will show that the
All right,
state...
quick break. We'll be back, and we'll pick it up right where we left off after this. Stay with us.
Buckle your seatbelts, folks. A lot to cover tonight, like we do every night here on Closing Arguments. Things are heating up in the case against the Doomsday couple. On the docket is the killer clown murder trial. New developments in the Ahmaud Arbery shooting. Shocking videos you have to see to believe. You will see the evidence. You will hear the arguments. And ultimately, you will hear the verdict.
Closing Arguments with Vinnie Politan. Tonight at 8, 7 Central. Only on Court TV.
Hi, folks. Medicare Part C plans with extra benefits like getting money added back to your Social Security.
Dynamite! Call now!
Call 1-800-561-2049. That's 1-800-561-2049 now.
Welcome back to Court TV and our continuing coverage of Florida versus Curtis Reeves. We're listening to the opening statements this morning. Let's go back into the courtroom and pick up right where we left off.
The evidence will show that the state will present some witnesses that say things that's favorable to their side of the case. The evidence will show, and I know, because I just heard the opening statement of the prosecutor, that the prosecutor's argument is going to be that Mr. Reeves just made this statement during his interview, his voluntary interview. So you're supposed to believe one, that's what they're telling you, and then somehow not question the other, think maybe there should be more details to the other. Maybe the detective should have gotten back to Mr. Reeves and spoken to him. He was willing to do it. So what happens when Mr. Reeves gets back in, as he's coming to his seat, Chad Olson turns around and says, "I see you turn me in." Words to that effect. Mr. Reeves at this point, seeing that Chad Olson put his phone away, leaned forward and told him, "I'm sorry, if I knew you put your phone away, I wouldn't have gone to the management." You're going to hear from Nicole Olson. She's going to tell you that from the first time Mr. Reeves asked Chad Olson to put his phone away, they took it as a bossy way to ask. Why is that important? That's important because Chad Olson gets annoyed. He was annoyed. That's what you're going to hear. That's going to be a description. Annoyed when Curtis Reeves asked him to put away his phone. But he's just not annoyed right then. He stays annoyed. Think of this. He's stewing like a pressure cooker ready to pop. Because when Mr. Reeves gets back, he's still annoyed. Mr. Olson gets up. He turns around. This is a movie theater. He turns around in his seat and leans over his seat. Other witnesses are going to tell you that. You're going to hear from Angela Hamilton, who's the wife of the off-duty Sumter deputy. She's going to tell you she saw him lean. The deputy's going to tell you that too. You're also going to hear from Joanna Turner. Again, if the state doesn't call her, we will. She's going to tell you she sees a throwing motion. And I'm going to show you this morning that part of the video. So you can see that there's a throwing motion. There's a throwing motion, and then about 10 seconds later, this is still going on. Nicole Olson is trying to hold her husband back. I mean, think about this. You're going to see Nicole Olson. Her left hand was on Chad Olson's chest. My arms are long. Hers are not. You'll be able to see it. The evidence will show that her arms are short. And so we can only imagine that Chad Olson had to be on top of her, right? She's in her chair, coming over towards Curtis Reeves. Again, I'm going to show you some video this morning. You're going to see that. So this isn't about popcorn. And how do we know that? We know that because we're going to present a use of force expert, Roy Bedard, an expert that testified for the state. In fact, this very office not too long ago, this prosecutor's office. And he's going to tell you that it's impossible that Curtis Reeves discharges firearm in response to popcorn. The times just don't add up. It happens so quickly that nobody humanly possible could have fired in response to throwing popcorn. Prosecutor told you, well, you're going to hear that somebody said, "Throw popcorn at me, will you?" You know what Nicole Olson's going to tell you today? After the shooting, Curtis Reeves didn't say anything. So who knows if this is some kind of faulty shared recollection? And let's talk about that. Prosecutor's right. They had over, Pasco County Sheriff's Office had over, I would say 80 and 90 officers that went there. Everything from school resource officers to agricultural officers. They had officers from departments I frankly had never heard of. They were all there. Yet we're supposed to believe that they were all there, but somehow they didn't hand the witness statements. Witness statements are essentially the police go there and they say, here, I'm going to give you a witness statement, write down, tell me what happened. Something to that effect. Very general. What they're supposed to do is if two people are together, they say, okay, I want you separated, you go over here, you go over there, because I don't want the witness statements contaminated. Officer after officer will get up there and tell you that. Our expert in crime reconstruction will tell you the same thing, Michael Knox. He'll say it's rule number 1, learn it in the academy. As a rookie, you know to separate people. So you have 90 police officers, 70, 50, whatever the number is, there aren't just 2, and they let everybody congregate, and they let everybody fill out things together. 2 of the forms that were filled out by a couple were the exact same. The wife filled them out for both of them. So if somebody says, well, he said throw popcorn at me, is that something that you can really believe? So Mr. Reeves turns after speaking to the manager. Things happen really fast after that. Cole Olson will tell you it happened fast. It happened fast. I'm not sure if I was standing up or sitting down. I think I was trying to get up. That's happening fast for Curtis Reeves, and for your consideration, that's happening fast for you. Again, Nicole describes her husband and his words as agitated, as mad, as angry. Other people in the theater will say the same thing. In fact, today I think you're probably going to hear from Hamilton, Mrs. Hamilton, Angela, who is the wife of the police officer who was there off duty, and you're going to hear from her that he sounded agitated. Other witnesses are going to tell you the same thing. One witness, I think his name is Alan Wolf, is going to say, I thought from what I heard, and I only heard one of them, from what I heard, I thought a fight was going to happen. He said he only heard from one of them. Nicole Olson will tell you that her husband was the louder of the 2. She was right there. Curtis Reeves has a gun in the movie theater. Well, guess what? Curtis Reeves has the right to carry that gun. In fact, under the Law Enforcement, LEOSA, Law Enforcement Officer Safety Act, enacted by the United States Congress, not only does he have a right to carry a gun, he's encouraged to carry a gun. Why? He's encouraged to carry a gun because if you're a police officer, you might not remember some bad guy that you put in prison, but guess what? That bad guy remembers you. And so you're encouraged as retired law enforcement to carry your firearm. The off-duty police officer in Sumter, he had his gun with him too. Didn't have it on him. His wife had it in her purse. She didn't have a license, but at any rate, he did have it with him in some fashion. So he had a right to carry a gun. He was encouraged by law to carry that gun, Curtis Reeves was. After the shooting, what did Curtis Reeves do? Took the gun, put it on his lap, on his knee.
As we approach the top of the hour, we need to slip in another commercial break here. When we return, we'll resume the opening statements. Julie Grant will be here. Stay with us.
Big George Foreman here, and if you're on Medicare like me, listen to this.
Are you tired of paying for every doctor and dental visit? Worried about the cost of your prescription drugs? Concerned about deductions from your Social Security check every month? If you're new to Medicare, moving, or losing coverage, you may qualify for a special enrollment period and be eligible to enroll in a Medicare Advantage plan that may save you money. Did you know the monthly Medicare Part B premium has increased to $170.10 for 2022? If you qualify for a special enrollment period, you could be eligible for a plan with the Part B reduction.
Website. In these unique times, you can still make a difference. Fundraise with custom shirts today.
TV Live, your front row seat to justice. I'm your midday host, Julie Grant. Today is the day that we've been waiting for. This is opening day in the movie Popcorn murder trial. We know that a homicide was committed in a movie theater in Tampa, Florida 8 years ago. But the question is, was that homicide justified under the law? The state says it was murder. The defense says it was a justified justifiable killing in self-defense. We're going to go back in now and hear more of the defense opening statements. We're picking up exactly where we left off.
That's where it was retrieved by the off-duty officer. In the meantime, people see Curtis rubbing his head, adjusting his glasses. You're going to hear various accounts of that. Police come in, handcuff him, take him out. In the meantime, Curtis is concerned. He's concerned that somebody's going to get hurt. He knows that when these sort of calls come out to law enforcement, when they hear there's a shooting in the theater, they're coming in, I guess, hot would be a term. They're coming in thinking something might be happening here. And so he's concerned for his wife to move over. His son comes and gets his wife and takes her out of there. And she is interviewed, Vivian Reeves. When police interviewed the off-duty Sumter, they interviewed the wife with the husband present. Not the best technique. I'm sure it was for human purposes, but it just doesn't help the investigation. Let's talk about the little bit about the investigation. Number one, you already know that these individuals were just given these slips to fill out and willy-nilly just let go. They weren't separated until a while later. That's not good. The detective who arrested Mr. Reeves, he arrested him before he went into the theater. Before he went into the theater. Here's something else. There's a video. We all know it. We've talked about the video. Guess what? That detective didn't even go to look at the video. Imagine that. Police work 101. Robbery at a 7-Eleven. I'm going to go ask the guy behind the desk, is there a video? Shooting in a movie theater. Maybe consider whether it's justifiable use of force. Let me see what I can see on this thing. Doesn't look at the video. What happens to the video? That's interesting. What happens to that video is in the middle of the night, corporate. The owners of the Cobb Theater sent somebody at the middle of the night to take those hard drives away to Alabama. And when the Pasco County Sheriff's Office finally realizes that this is probably something they should have and look at, days later, they go to where? Corporate? No. They go to a lawyer's office in Alabama to pick up these hard drives. And then guess what happens to the equipment? It gets dismantled. And why is that important? Because there's going to be an issue in this case regarding, you're going to see in these videos, as crummy as there are, there's something that looks like a light. It happens about the time when Curtis Reeves got hit by a cell phone, got punched, something happened. We know for sure that the cell phone was found between Curtis Reeves' feet. That we know for sure, and we have a photograph of that, and everybody agrees with that. So how did it get there? Well, the video seems to show that, but it's not really clear. And so what we did is we got Michael Knox, went to the theater at 2 in the morning. We tried to recreate it. The problem was that we brought the shoes to see if we could do something with that. The problem was that the whole system had been dismantled. So we couldn't conduct any sort of investigation to be able to either rule out or rule in what that reflection was. Curtis Reeves did have a reflection on his shoe. You're going to see that. We know he does. You're going to see it flat. It looks like it pops up on the screen. There are all kinds of weird little white spots and all of that. Like I said, it's not the finest of videos. But even if it is his foot, then is that he crosses his leg? Because by the way, this is very important, and I almost forgot it. When Curtis Reeves comes back from speaking to the manager, he comes in, reaches down, gets his popcorn from his wife, Vivian, puts it in his left hand, and crosses his legs. So is that somebody that's really engaging somebody again? Is that somebody that's saying, ha-ha? Is that somebody that's there to rub it in? Or is that somebody there that's just trying to enjoy the movie and apologize and say sorry? Because that's what happens. You can see that on the video. Okay, then the state told you there's a lot of witnesses. They may not call some. There's some crucial witnesses, some vital witnesses you need to hear from. If they don't call them, we will. You'll hear from them because you need to hear from them. Now let's look at some of these visual aids I had to kind of illustrate what I've been talking to you, if we can. Your Honor? Thank you. File 1, please, Mr. Funderburk. These are some of the certificates of training that Mr. Reeves collected over his many years. 328 hours of training in the police academy, 328 hours. Florida Institute for Law Enforcement certificate. Department of the Army certificate of training for the Tampa Police Department. State of Florida Police Standards certificate of recognition. FBI certificate of attendance, Special Tactical Firearms School. Survival tactics. Next page, please. Tampa Police Academy, advanced training, inspector techniques, so that he can train his men, so that he can ensure their safety, so they can come home to their family. FBI training school, effective communication. Commission on Criminal Justice Training. Department of Justice, standard and training. His training is not just local, it's not just state, it's nationwide. It's federal and it's local. Next page, please, Mr. Funderburk. These are some of the training he received when he was with Bush Entertainment. Because now, although you're applying the principles of your law enforcement training of 27 years, and you're training people in law enforcement for 27 years, you're looking at it from the perspective of the enjoyment of an experience, like being in the movies, right? Okay. Let's go with number 2, please. Ready? All right. Let's get inside the movie theater. The cameras are somewhere back here, up here high. I think they're 30 feet up. And they are facing down, but they capture the first few rows. Mr. Curtis Reeves and Vivian Reeves are somewhere around here. Chad and Nicole Olson, Mr. and Mrs. Olson are somewhere here. You have Mr. and Mrs. Reeves are in these 2 seats here. You have the Hamiltons you're going to hear about, they're out here. And the Turners that I talked to you about, they're over here on the same row. And by the way, Angela Hamilton, even though she was 7 to 9 seats away, still could hear Chad Olson's voice over the previews. So the prosecutor's telling you, number 1, they're a whole row away. They're a whole seat away. As if to create the illusion that they are an ocean apart, or at least very far apart. Not true. Line 3. Ready? This is that stipulation the state told you about, an agreement that Chad was not texting his effing daughter, as he said. associated with Facebook, link to Facebook, profootballmock.com. A missed call around that time. So, it wasn't true what Chad Olson said. Is that part of just being angry? Number 4, please. Ready? Ready? All right. Before we, don't start it yet. Before we watch this video, let me tell you a little bit about it. There's several cameras. This camera that you're looking at here is kind of the front as you're walking into the area where the theaters are, past the concession stands and all of that. There's another camera at the front desk where you actually pay. Those are in color. What you're going to see in the theaters.
We need to step aside for a break right now, but don't worry, you're going to see all of this and all of that video when we come back. We're hitting pause. This is Court TV Live, your front row seat to justice.
It's a tragedy that captivated the country.
Police officers shot and killed Breonna Taylor in a botched raid on her home.
Somebody shot my girlfriend.
Only one of them, Brett Hankinson, is facing charges.
The charges have nothing to do with the shooting death of Breonna Taylor.
The indictment had to do with bullets that went into an adjacent home. Please continue to say her name.
The Breonna Taylor botched raid trial. Live coverage starting February 22nd, only on Court TV.
First time that I used the personal microderm, I found it was so easy to use. It's so
department I talked to you about is going to tell you how that works. The way it works is when you watch a surveillance video, like a home surveillance video, in this case, it's in a theater, you look at it, it appears that something is constantly happening. What happens in these motion-activated videos is that when the recorder actually stops recording so that it's more pleasing to the eye, it'll continue the same images. The same images, same image, same image until something else happens. What these videos do is take away the images where the camera is not recording. And so what you're going to see, there are going to be large gaps because that's what the camera was actually recording at the time. Go ahead, Matt. Mr. Reeves, Mrs. Reeves. Okay. Pause it, please. Okay, walking into the theater. You can see they're taking their seats along the back row. This is the Sino Bistro area we talked about over here. There are two cameras you can see. One obviously is recording from this side. The other one is recording from over here somewhere, and that's this, what's called the camera 12 recording. This black screen here, this is what I talked to you about. So what's interesting about this is you would think that if one camera is sensing action, is sensing movement, that both cameras would. But as you can see, that's not the case. And how they work exactly, no one knows. They took the cameras. The hardware, they took the drives, and I mean, this is what we have. And so you will see, this is what you'll be seeing. This is the timestamp at the bottom. So you'll see actually how long things take to happen. So Curtis Reeves, Vivian Reeves come in. What is that? The answer is, don't know. Could be his popcorn. Why is it shiny? Poor resolution. Don't know. That's what the camera picked up. And so that's Mr. Reeves sitting down. Curtis Reeves, Vivian Reeves. 13, 14, 47. They go down into the thousandths of a second. Okay, let's go forward a little bit, please. Mr. Funderburk. Sit down. Popcorn in his left hand. Okay, let's move forward a little bit. We're skipping parts of it because nothing's happening. You'll be able to see the whole thing with all the black screens. This tells you obviously when the next image will be appearing for camera 12 and camera 11 respectively, I should say. Okay. Okay, Mr. Reeves leaning forward, getting up. Now this is when he's going to see the manager. All right, let's stop it, please. Go back a little bit. Mr. Funderburk. Okay, let's let it run there. All right, hold on, stop. All right, putting down his popcorn. Go ahead. Stop. Back a little bit. He's using the wall for his balance. That's not what the prosecutor told you. The prosecutor told you just zips down the aisle, trying to make it seem that way anyway. I know he didn't say that.
Your Honor, I haven't, this is argument. This isn't what you're going to see. He's pitting one against the other. It's not proper for opening. This is pure argument.
I'll rephrase
I object to it.
I'll rephrase. What the evidence will show, not what was represented to you by the prosecutor, the evidence will show that Mr. Reeves did not walk down the aisle with any ease. The evidence will show that Mr. Reeves used the wall for balance. Go ahead, Mr. Funderburk. Here he is leaving. Mr. Reeves going to the service desk. Okay, let's pause it, please. All right. Thomas Peck, Manager, service desk, Dawn Michelle Simpson. Those are the players. You're going to hear from them. Both of them are saying, and will say, because it's the truth, that when Mr. Reeves can't come.
Your Honor.
Sustained.
Thomas Peck is going to say that Mr. Reeves was calm. The evidence will show that Dawn Michelle Simpson will say the same thing. You can make up your mind to see if it's consistent, because the judge is going to tell you that you can judge the credibility of a witness to see if their statement matches up with another's. That's your decision to make. They're both going to say the same thing. Continue, please, Mr. Funderburk. Here's Mr. Reeves at the desk, waiting his turn. Waiting for Ms. Simpson to write down the movie posters she's looking for. Back into Theater 10. Sitting in his seat, got his popcorn in his left hand. Okay, stop there, please. Let's go to, if you would please, file number 6. What you saw very briefly on this camera is isolated because a video is just a series, like a movie is, of frames. These are the frames that are within this video. Okay, Mr. Funderburk, if you would toggle forward, please. Okay, hold on. Chad Olson. Chad Olson coming over his chair. That's not the popcorn. That happens shortly. So although the argument was made that the evidence will show this is over popcorn, the evidence will show that this is a first attack. Mr. Reeves is back in his seat, popcorn in his hand, getting ready to enjoy the movie. Explosion. This is what happens. Go ahead. Back and forth, please. Okay. Here's that. That's that shiny thing. Is that the cell phone? We have no way to prove it. We have no way to prove it because, frankly, the theater did what they did by moving things around. And so we can't prove it. But certainly, we can see, please, Mr. Funderburk. Is that the reflection on his shoe? That's for you to decide. I can't tell you what it is, and nobody can. But clearly,
Ron, I object. This goes beyond opening statement.
the evidence will show that Chad Olson, I'm sorry, Your Honor, I didn't give you a chance to rule.
Sustained.
Okay, it is rare to see objections happening in opening statements, and we've seen a few made by the prosecution. Just noting that that's odd tells me this is going to be a very contentious battle fought in the courtroom. We're hitting the pause button, so to speak. We're going to pick back up right after this quick break. Thank you for being with us here on Court TV Live.
Do you know you can get your prescriptions for less? You can with GoodRx, the free app that gets you discounts at your local pharmacy.
If a customer is about to pay a high price, I have them check GoodRx, even if they have insurance.
You can also compare prices and have your doctor send it where it's the lowest.
Can you send it here?
Sure. It works at over 70,000 pharmacies across the country.
I use GoodRx at Walmart.
I use it at Kroger.
We're a Rite Aid family.
Here's a tip. Before you top off your prescription, just check the app.
To save on your prescriptions, check GoodRx.
When you enter your home, what do you smell? Is it fresh air? Or are you smelling soil?
Tells me this is a very contentious battle these teams of lawyers are going to be fighting. That's Curtis Reeves, the defendant, 79 years old as he sits there today. He was 71 at the time of the incident. A decorated police captain started up the SWAT team in Tampa, Florida at his former department. Now he finds himself on the other side of the law. Let's watch.
Didn't just talk to Mr. Reeves and didn't just reach over the feet, over the seat, the evidence will show this. That Chad Olson at 13, 26, 25, 422 came over his seat to the extent that his head and his arm appear to be in the road. They're in the road. One more time, please, Mr. Funderburk, for us. Okay, thank you. Let's go back to number 4, please, Mr. Funderburk. Okay, go ahead, please. Okay. Let's go to, if we could please, let's go to file 8. All right. Was it over popcorn? It's your decision. The evidence will show that it happened mighty fast. It happened lightning quick. These individual photos strung together will put you in the place of Curtis Reeves, because you'll be able to see what he saw. Did he see somebody who announced, "I'm going to take your popcorn"? There's going to be no evidence of that. Did he know that Chad Olson was going to take his popcorn? He's a man. He's got popcorn in his lap. Prosecutor talked about the evidence will show that Curtis Reeves invaded Mr. Olson's space. We've already had one invasion of space, if you will, after a violent outburst. Now we have
this is inappropriate for opening argument.
The evidence will show that there's already been one violent outburst. And this is the second. Go ahead, Mr. Funderburk. Okay. Step 1. Chad Olson. His arm coming across. Stop it. Again. It certainly appears to be a head and an arm coming across. You make that decision.
Is there an objection?
Yes, Your Honor. It's one thing to say what the facts are, but he's interjecting his own personal opinions in an opening statement. It's not appropriate.
Let's stick to opening statements. What's his name?
Let's do it this way. You're Curtis Reeves, you're sitting there. You don't see someone taking your popcorn all at once. The evidence will show that you don't. Mr. Reeves will say that he didn't know there was popcorn being thrown. He didn't know there was popcorn being taken. Go ahead, Mr. Funderburk, if you would. Now look at this. Okay, stop, please. We have another motion, right? Motion appears to be the arm.
Your Honor, again, I object. These personal interjections of his personal assessment of the video is not appropriate in opening statement.
Let's discuss this at the bench.
All right, I'm going to object to that objection because that is what's called a speaking objection. Those are not allowed. You're not allowed to just stand up and say, Your Honor, what this attorney is doing is improper because they shouldn't be going beyond this. No, you object, state the basis. Objection, hearsay, objection, speculation. You state the basis. That is it. And here you see the state is visibly getting rattled about what the defense is doing in their open. So while they're at sidebar, let me bring in my guests to see what they think about this and what the jury might be thinking. I have with me retired police commander and the host of the Profiling Evil podcast, Mike King, is on the program, and criminal defense attorney and former prosecuting attorney, Daryl Cohen. Great to have you both. Mike, let me start with you. Your reaction to what we're seeing there in the open.
I agree with you. I think it's really interesting the amount of emotion that's going into just the opening statements and the bantering that's occurring. This is going to be a case that boils down to emotion. Does this person have a right to stand their ground? Did they overreact? I mean, it's just really difficult in any conscious mind to somehow equate even the destruction of popcorn as a reason to use lethal force. But having been a SWAT officer, having been a police officer, I know that you go through years and years of training where you learn that when certain things happen, you then satisfy what you have to do in order to pull your weapon, in order to use lethal force. But does popcorn do it? Holy cow, this is going to be a tough one, Julie.
Sure is, Mike. So glad we have you. And Daryl Cohen, want you to weigh in, please. Your reaction on what we just watched.
Well, Mike, back to Harry Carey and holy cow. So what do I think? I think that, number one, this lawyer is doing a masterful, though very tiny, meticulous job of setting the stage. He is showing exactly who his client is and what his client has done. He is telling a story. He's telling a story that the jury is listening to. It's not about popcorn. It's about being hit by a cell phone. It's not about popcorn. It's about being hit in the face. It's not about popcorn, but about somebody on the seat in front threatening him, someone who was much younger. And I think that the state attorney's office is objecting not because they think there's an objection that is legally appropriate, but because they want to break the rhythm. Oftentimes we will object just to break the rhythm. And in my view, he's doing an excellent job of doing exactly what he should do, though it's unusual. He is showing evidence now that the jury will then see at a later time.
And when you say he, you mean defense counsel, Daryl?
Absolutely.
Yes.
I'm sorry.
Yes. No, that's fine. I
incorrectly.
just wanted to clarify. Right. So your theory is that maybe the state knows he's on a roll, so that's why they're jumping up and just trying to stop him.
Absolutely. You're trying to stop the jury from being swayed, the jury from being, in effect, hypnotized by this defense lawyer, and the jury being hypnotized by looking at this gentleman who was a retired police officer who's now 79 years old, walking into the courtroom with a cane. The prosecution has to stop it.
I have to say, and we have to take a quick break, but before we do, defense counsel has not gotten rattled at all. Every time the prosecutor gets up, and he's even just talking, even though there's an objection out, and Mike and Daryl, you both know this, when there's an objection, you stop and you wait for the court to rule. He just keeps going. He's just like a steamroller and going and not fazed by what the prosecution is trying to do here. We're going to watch and analyze much more for you here on Court TV Live. Mike King and Daryl Cohen are going to stay with us. Want you to do the same. We'll be right back.
Behind the news,
several big pandemic headlines with the latest from Washington.
there is the why. At Newsy, we take time for context.
Can you break that down for us?
Offering the information you need now more than ever.
We'll focus on facts versus myths.
That could mean a big change for vaccinations.
Could this policy put more healthcare workers at risk?
This is the news with the why.
Newsy. Watch free national news 24/7. Rescan your TV antenna to find Newsy or stream live.
Man, Drive Time makes it easy to buy a car. You can pretty much do it all on your phone and your own time. I got approved, found tons of cars.